All right.
Hey, everybody. I'm really excited for this opportunity really to invite one of the longest experts in midwifery professional liability insurance that we have, Izzy Teitelbaum from Contemporary Insurance. I've known Izzy probably 3 decades. I gotta believe it's been at least 30 years, Izzy. A true supporter of the American College of Nurse Midwives, and he graciously is coming on tonight to spend some time with Joe from Grow Midwives to talk about primarily professional liability insurance and its intersection with tail coverage. So I'm going to turn it over. Thank you both for being here.
Thank you. And it most certainly has been about 30 years.
Yep. Like I said, they're both were in the sandbox at the time. I'm going to start with the traditional PowerPoint and talk through a few things and then open it up to a general forum of a conversation. We have as our guest, Sarah, who's going to help us pose some hypotheticals here. And we're going to just kick her off. If you've seen it now, you see it. Our point here, we've given you our credentials, but we're trying to, the joke of nose to tail really has to do with the fact that insurance coverage is often a question of what you're doing now, but also what you had done professionally before, and then tail coverage, which is a major issue. The objective of what we want to obtain here is to increase the awareness and understanding of the elements related to professional malpractice insurance in order to prepare for employment options when you start doing contracts. That's really what we're after here as we're looking in this conversation, is focusing on contracts and then echoing the ramifications otherwise. As consultants in Grow Midwives, what Grow Midwives is beginning to see is contracts that omit any type of coverage. We reviewed a couple over the last 48 hours, and interestingly, I think 2 of them didn't have any kind of conversation of any relevance about what the coverage was. Many of them don't state important elements such as what are the policy limits and the kind of coverage. They either don't address at all tail coverage, and if you don't know what kind of policy it is, we'll get back into that here in a minute, occurrence-based versus claims made, you really don't know what the tail coverage questions are. And some of them actually require people to prove up that they are covered for any liability that could have occurred before you become employed. And so those are what's going on. Also interesting and fascinating and terrifying is the fact that in the last 4 weeks, we have consulted with people who are facing tail coverage costs from leaving a job that may have paid them $85,000 to $250,000 a year. The tail coverage is $45,000 or $50,000. And so they're trying to figure out what to do about that and what that matters. We're trying to, I'm going to go straight to this. Let's look at some contracts real quickly. First, this is an example of what a contract might have to say. And it is from a contract that we reviewed. Employer shall purchase and maintain at its expense comprehensive professional liability insurance coverage as employers shall deem appropriate, covering the acts and omissions of employee in the normal course of this agreement. Okay, first, that means that you're not getting any coverage for anything outside of the agreement. So if you do any other kind of activity for any other person or entity, like whatever, volunteering somewhere, your policy doesn't cover that. And the form and amount of which shall be determined by its employer in its sole discretion, meaning you're not guaranteed any specific kind of coverage or guaranteed coverage limits. And upon termination, this contract requires you to purchase your own tail. So when people see this in contracts, they think, well, of course, I would be responsible for my own tail. It's more than that. It's saying that you actually have to go buy a policy. So even if you looked at your own history and you worked someplace for a year, and maybe you worked someplace for a year and you actually never did deliver anybody or whatever happened, you still have to buy a tail coverage under this contract language. So that's some of the pitfalls we're talking about. If this agreement is canceled and the triggering event means the agreement ends, then the employer shall obtain from an insurer continuing insurance coverage in such amounts as shall be mutually acceptable to the employer for claims arising out of services performed under this agreement prior to the triggering event, but they're only going to cover you for 5 years. And Izzy may later have a note or two about that thought. But they're going to buy some kind of tail coverage for 5 years afterwards, or they're just going to continue the policies that are in effect for 5 years and then not give you any tail. So those are the little bit of issues, including the fact that it's mutually acceptable to the employer, which means you don't get to vote on the mutual acceptability. Contract 3. Let you read that for a moment. This basically says you're not getting any tail. And sadly, I think we picked a bad example here. That basically refers back to the sections of the agreement. But basically, if they terminated you without cause, that agreement would give you coverage. Here's another one that's coming up more. And it's closer to what if Grow Midwives were advising a practice, trying to strike the balance between the incredible cost of tail, which we'll get into, and dedicated employee performance and encouraging employees to stay for a period of time. What this does is it says, we're going to cover your tail, not at all for the first year, 2 years, 20%, etc., until over 6 years, you will cover it all. And this is designed to incentivize employees to stay for a while. And Izzy can talk about how tremendous of a benefit that would be if you stayed the 6 years, because we'll also talk about the idea of what happens with how, and we're going to segue into this right away, how we price out the idea of what malpractice coverage costs, because, and I'll sort of use this as a segue point. We very recently reviewed a conversation and a contract with someone who said, I'm not too worried about your tail coverage, and I don't think it's going to be very expensive because I hired someone just out of law school, or just out of midwifery school. And they worked for me for about 6 months, and then they decided just to move on because they wanted to do something else. And I thought their answer was weak, and it only cost them something like $1,500 to cover the tail. Well, that was meant, probably with good intentions, to say that this tail coverage is a non-issue because of their experience, that this one person who had just come from new practice and had just worked with them for a number of months experienced a nominal amount for tail coverage. But like I said, we're seeing these huge bills. So I think the first thing we need to talk about is how does the industry look at how to structure the pricing of malpractice insurance, and all tail is to continue that policy. If I'm fair, right, Izzy?
You are right.
And how do we structure? I was going to do a graphic, but I was told not to because it looked dumb. How is the pricing structure done for malpractice insurance, and why does it look that way?
So just to give a brief answer, the answer is it all deals with insurance company profitability and the ability to cover losses that come in. So in a nutshell, back in the mid-'70s, when St. Paul insurance company provided insurance to most healthcare providers, a strange thing began to happen. These policies were all written in an occurrence format, and that meant that nobody had to buy tails. But what St. Paul experienced is it was selling policies with $100,000 coverage, and 3, 4 years later, when the claims came in, they were being paid at $1 million. So it never expected to even pay 100,000. They expected most claims to be paid at 30. So what basically they found is that they were not collecting an adequate premium for the amount of claims that would have to be paid out in the future, especially as policies began to rise to, as claims began to rise to the $1 million level. So what they did is something really smart. They abandoned the market, totally abandoned the market. Healthcare professionals had no coverage almost anywhere. And this persisted for a year or two until St. Paul developed this claims made policy and came back into the market. Basically what a claims made product does, it allows the insurance company one last bite at the apple to make up the premiums that it should have charged early on if it knew how bad how the claims market was going to be. And so that's very simple. That's all it does. It protects the insurance company. It gives them a chance to charge a little bit extra premium. In fact, in some carriers you see now, the tail is totally loose. There's not a premium charge on the policy. The premium will be determined when you cancel. Now, for midwives, it's a little different. For midwives, you see tails are often tied to the premium. So some companies, for example, will charge 125% of the premium for 2 years of tail coverage, 150 for 3 years of tail coverage, and 200% for 5 years of coverage. When you see that, that means that after the 5 years is over, there is no coverage. The tail is expired. And you see other companies that offer tails at, with our company is at 115% and the tail is forever. But no matter what the tail costs, it costs more than most midwives are prepared to pay. And that is really the issue. So I think, one of the things that your company does that I think they do very, very well in the planning is to prepare a midwife to deal with the issue of tails so that either you can put money aside for it as part of your, whatever your income is, you put a little bit of money aside every year. And so if you have to pay for a tail, if you weren't able to negotiate a better rate, you're there. And that's what makes the work that you do so important. But then in a nutshell, that's the tail. These tails are very, very important because even though you assume that you did everything right, and even though you never had a delivery, if you did a breast exam and missed a lump, or even if you didn't miss a lump, but you're alleged to have missed a lump, and you are sued within your statute of limitations, the payout can be really, really significant. So I can tell you that there's not a year that goes by that I don't get a call from a midwife who's bare and who has a claim against her. And it is when that happens, everything becomes very serious. Your assets are at risk. Maybe you're very fortunate you have no assets, so the plaintiff's attorney decides you're not worth the effort. But in most cases, if you end up with one of these attorneys, let's say you have an outcome that's small, and you get one of these attorneys who's advertising at night by, if you have a phone, you have a lawyer, one of those kind of guys, he's happy to get a $30,000 settlement, and he may actually go after you personally to get that. So the tails become very, very important.
Your thoughts bring up a couple of things, and they are the lawyer-related things. Statute of limitations is an interesting and important issue. When you're taking care of individual patients, that patient relationship is usually pretty well safeguarded by a statute of limitation, meaning that if you know whatever happened that day, such as, what happened in a delivery, and you felt like your person was damaged in some way, that there was some kind of breach of the standard of care, you have usually about 2 years to make your claim. The problems start mounting on the first line by the fact that the claim doesn't start accruing until you know you have a problem. And Izzy's example of the breast examination, and oops, I thought, that wasn't a lump, or I felt a lump and told somebody it was benign without asking for any further testing, or we got testing back and never told anybody about what that positive test had to say, all those kind of scenarios. The statute of limitations doesn't start until the patient becomes aware of the problem. And so you could wind up with working for 2 years with somebody, then someone coming up a year or two after that saying we have a problem and I just found out about it, or 4 years after that. When it comes to delivering babies, you have an exponential kind of thing that happens. And that is that if the baby is damaged and has a claim, the baby's claim doesn't actually ripen until they reach adulthood in most states. And if the baby's claim doesn't ripen until they reach adulthood, then you may wind up with doing a delivery today called a shoulder dystocia issue. You have that baby that's delivered, you feel like you did right, it's a shoulder dystocia issue. The baby then reaches 18 years old and decides they can't work their arm right and wants to file a claim. They still have the statutory limitations tacked on to the end of the minute they became an adult. So you have 20 and 21 and 23 year periods of time that could happen for delivering babies. So that's where this tail gets very scary, especially when they say your tail is only good for 5 years out, et cetera. You're cleaving off an amazing amount of liability by saying 5 years of liability, because you're actually getting rid of huge groups of this. But I know of a case in which there was a shoulder dystocia. Someone went through the process of being sued. The lawsuit was dismissed. Years later, then someone else stands in for the same child while they're still a minor, files a lawsuit, and the lawsuit proceeds and winds up going to settlement years later. So you've gone through the whole gambit a couple of times. So then that brings me back to a football I'll hand back to Izzy, and that has to do with the fact that the value of insurance simply for the coverage of legal defense.
Okay, so there are a few policies out there that do provide coverage for legal defense. And what that means is that if the person who's defending you does well, and you go to trial and you win, you're great. If you go to trial and you lose, you're not so great. And what happens is that, as Joe mentioned, the statute of limitations can be far, far later than when you saw the patient. In fact, every state is different. Some statute of limitations are from discovery, some are not from discovery, some are 2 years, some are longer. So every state has its own. But the problem becomes that is the jury. When you have defense only, and if you have a serious outcome, cerebral palsy, for example, where the child can have a lifetime need of care, you end up, and you can bet that this kid is going to be put up in front of the jury. So what happens is you land up with a situation where the jury says, I know she has insurance, and I know that this child needs a recovery. And that attorney's done a great job showing that there was absolutely no negligence, no culpability, but the jury said the insurance company will pay it. Let's give them $1 million. So defense only is better than nothing, but it is close to nothing if you have a bad outcome.
Mm-hmm, mm-hmm. Yeah, the defense, just running the defense, as we've talked about a little bit, this idea of you don't have any coverage, therefore you're judgment proof, still doesn't cover the problem that you would have had to have invested in fairly significant amounts of legal fees to prove your judgment proof, and to have nursed the lawsuit along enough. This can happen one of two ways. A plaintiff's counsel begins the process of investigating a claim, and if they have time under the statute of limitations, they may do some pretty serious conversations with somebody saying, what kind of coverage do you have? Who's your insurance company, et cetera, and decide whether or not they're going to file suit. But if somebody walks into my office, and I don't do plaintiff's law, but if somebody walked into my office and said, I believe that I was wronged in a medical malpractice issue, and that when was that? Well, that was last August. And I know I have a statute of limitations of 1 year for that case. I'm either not going to take the case or I'm going to go ahead and file a petition and go ahead and initiate lawsuit and serve the other side with a lawsuit in order to preserve the statute of limitations, because I don't have any time to move. I can't send, I may be able to do a courtesy because it's August. I may be able to send something that says, okay, if you don't respond to me in about 2 weeks, I'm going to go ahead and file suit. And I have to, no, don't blame anybody. This is what we're given. But we have to start that lawsuit. Then you're in front of somebody with a lawsuit to file an answer. And there are such things called affirmative defenses. And those affirmative defenses, if you don't say them in the answer, you've waived them. So it takes significant legal resources to be able to even enter the dialogue just to prove that you don't have any money. So you could pay $10,000, $15,000 worth of legal fees, any number, I'm just making that up, just to prove you don't have any money.
So Joe, I think this, to put it in the perspective of the midwives that we're trying to help,
Right.
who want tail coverage. Let's talk about that first.
Yes.
And Izzy, you may be the one with the answers on this.
Let's give to Izzy.
Can they, how do they seek out potential options for coverage?
Okay, so that is a great question. So first of all companies offer tail insurance to their claims made insureds. They may not offer forever insurance. They may offer it for a limited period. Let's say one of the major carriers offers it for only 5 years if you have to buy it. But if you retire, they'll offer it for you forever after retirement for free. So let's start with the free stuff.
Yeah.
If you've been insured with a company for 5 years and you're about 55 years old and you retire, die, or become disabled, well, if you retire after 5 years and 55, you should get your tail for free, and almost all of those tails will cover you forever, even after you're not alive. So those are there. For death or disability, most of those companies will provide immediate coverage the day after you buy the policy. If you become permanently and totally disabled and you can't come back to work, you'll get a free tail. So those are your free tails, and clearly for death, you get a free tail. There are some policies out there that are really not recommended that don't provide some of those coverages free that way, but pretty much all of them that you're going to see, unless you're bargain basementing, are going to have those coverages. Having said that, if you need to buy coverage, with some companies you can buy forever coverage, and that means that from the time you buy it, if a claim comes in 100 years later, it's still covered. With some, you can only buy 1, 2, 3, 4, or 5 years of coverage. But once you buy that, you're going to be covered forever. So, or you'll be covered by that company. So that's if you buy it from your own company. What we are seeing is there are a number of carriers out there where the tail insurance is really expensive. So that usually you're looking at a multiple of somewhere between 200 and 250% of your premium. So if you have a $10,000 premium, you could have a $25,000 tail. And if that was the only choice you had, you'd either have to buy it from that company or go bare. But there are some companies that sell standalone tails. And a standalone tail means that that company will receive an application from somebody who's been offered a tail by their carrier. And let's say that carrier charges $25,000, that the alternate carrier will evaluate the claims history, the risk, the likelihood of claims, and may offer it for less. Now, it's not going to offer $10,000 for a tail with $25,000, but you may see a tail offered at $20,000, $19,000, or $21,000. So that is real money, obviously, to anybody. So a standalone tail can be purchased. Right now, I'm only aware of one company that's selling standalone tails to midwives.
Okay.
So it is rare.
And another question is, you know, if you're looking at this $45,000, $50,000 bill, which a couple of the midwives are, who are trying to get credentialed for their next job, and that job is requiring gap coverage, evidence of prior acts coverage. So they got to buy the tail to get the job.
Right.
They're saying, can we pay it off over time, or is it one lump sum?
So I'm not aware of any carrier that offers midwives time or financing to pay off the tail. I have midwives who borrowed money on their credit cards. I've seen midwives who've gone bare because there was just no way to afford it. I've seen some carriers give an extra 30 days to come up with the money. I mean, usually you have about 60 days from cancel. I say 30 days or 60 days, depending on the company, from the time of cancellation to purchase the tail. Sometimes you can get a little bit longer, but it's very rare because most companies used to not want to sell tails. Now they see it as someplace they can make a profit, so they're willing to play ball with you a little bit more.
So how realistic is it to advise a midwife to consider negotiating that the next employer purchase the coverage?
So I think it's all sales, and that's the beauty of it. So what Joe and I both do is sales. We do give good advice with our sales, and we give good representation, but it's about sales. When you're meeting with an employer, you're selling yourself to that employer, and you have to show value. And one of the ways you show value is exactly what Joe showed you earlier, which was a structured payout period, so that if you work for an employer for a longer period of time, they should have more invested in you, which means that if I've worked for 1 year and leave, all right, so I pay 80% of the tail. But if I work for you for 6 years, you owe me a little bit. I've shown you reliability. I've shown you loyalty. At that point, you should pay it. And as Joe, I'm sure, made clear, is it should be in the contract, because your employer will forget 6 years from now. So you need to really talk to people. Yeah. You need to talk, you make sure that everything's in writing. But yes, so that idea of the 20 and 20, 40, 60, 80, 100%, I see that in a lot of the nurse midwives that I speak with. I highly recommend it if you can't get the employer to agree to pay it all up, no matter how long you work. So obviously you want to tell yourself, look, you said you were going to cover me for the time I'm working for you. If that period is 1 day, or if it's 10 years, you promised me insurance, you should give it to me. If you can't make that sale, the structure is your next bet. And if you can't make that sale, then you ask yourself, is it worth it to take this job, knowing what my tail will be? And you need to get those projections. Make sure the employer gives you the name of the insurance company, call that insurance company, get projections.
This is where I think you and Joe really emphasizing the professional responsibility midwives need to step up and assume, because many of the people we talk to, even those out 10 or more years, are not experienced and are so trusting, believing that everybody's doing goodwill. It's part of our DNA as a midwife, that there is just some lack of confidence to have these incredibly important conversations.
The Ginger, I would add to that that there are many employers who have their first hire who know less about this than even the midwives.
You're absolutely right. So we do basically say, look, sometimes they don't know, it's not their fault. They've not hired a midwife before. Teach them, these are the things you need to talk about with them. But the timidity is still pretty prevalent among negotiation with midwives.
What we do see very clearly, either from the side of helping midwifery organizations or from the side of negotiations, is that when the dialogue starts, people start thinking about what their contract says. And sometimes these contracts are simply something that they've inherited by hook or crook, whatever came up. They took one from their sister that they got from another program, or some lawyer just looked up midwifery or nursing, advanced nursing practice contracts or medical practice contracts, copied the boilerplate and said, here you go. And nobody has ever given any thought to it. And so the dialogue brings a thought. I'm going to go back And I want to talk about this structure. I'm going to go back to that contract that had the scale. But before I do, I want to talk about just briefly the fact that of how, and Izzy will correct me, I think I can do it, say it faster than making him, say it too. And that is, malpractice insurance is priced, and we started on this conversation, but didn't get to it. Malpractice insurance is priced to cover risk. And the first risk year is cheap. The second year is twice as expensive, if not more. The third year carries all 3 years. The fourth year carries all 4 years. And so your malpractice insurance coverage goes up tremendously until 3 or 4 years out, and then it levels off. Am I right?
It's usually 5 years out, and then it levels off. And the reason it levels off is because by the 5th year, most of the suits that would have come in the first year have already come in. So statistically, it's shown that 5 years to maturity is about right to capture what may be the 90% of the claims that are going to come in.
And boy, statistics don't just mean what you might think in a poll. It means what these insurance companies have been burnt and cry about. So let's go think about that for a minute, and then go back to this loyalty kind of agreement that we have here. And notice how there's an exchange. And one of my biggest problems in midwives negotiating with large entities about how much they'll pay for the tail is it's not an even conversation. Why would you take an $80,000 job in which you might wind up carrying a $25,000 or $30,000 liability later? There's no motivation for that. So understanding that may make you reject the job. But this sort of plan that makes you responsible for the first year really doesn't carry that much cost for the midwife, and completely covers the company from any liability. But as they go on, they're picking up more and more liability, a tremendous amount of expenses. By the time you're at 6 years, as Izzy just said, 5 years out, at the 5-year mark, you've leveled on what that liability for tail coverage might be, because it's based usually off the cost of the coverage. And then after 6 years, that incentivizes people to go forward. So as Izzy was talking about the sales, that I wanted to go back and reiterate that as a point. I'm going to stop the screen share. That makes sense?
Makes a lot of sense. The thing that you always have to keep in mind is that with a claims-made policy, each year it builds on the year before, but it gives the insurance company a chance to make a change. So if the insurance company raises your premium, that's going to raise your tail. If the insurance company changes the percentages for tail insurance in that year, that going forward is going to change your exposure to the cost. So you can't be vigilant just in that first year. You need to know what you're buying, and you need to look at it each year when you make the purchase, because it is a significantly expensive purchase. You need to ask those questions year after year.
Well, and that brings me back to one of the things that comes up in every contract review is we tell people to get a copy of the policy and review the policy that they're getting, because a lot of these questions that we've talked about, like if you're 55 and older, are you going to get free tail? All these other things could be disclosed in the nature of this policy, and what is the nature of the contract between the employer and the employee, and are they agreeing in the employment agreement to work under the terms of this policy, or are they agreeing to work under whatever the hell policy you want to give us anytime you want to give us? And those are big differences.
I would also say that you should not hesitate to use brokers' time. So most of the brokers that are selling malpractice insurance to midwives really like midwives. They really support what midwives are doing. And so if you ask the questions, you can't go to the bank with it, but you can assume that if you ask the right questions, you're going to get an honest answer to the best of that broker's ability. And so what we know, most of the brokers that actually make a market in this, and they're good brokers, they really know what they're doing. They should be able to answer your questions. If something doesn't ring right to you, push harder. Yeah, ask the questions, make sure that you know the answers. If a broker says to you, got it, don't say yes unless you really got it. And because the broker's making money by selling you the policy, it's his duty or her duty to educate you on what you're buying.
I think we're right at the wrap up point, and that may be something to hand to Ginger. If not, I have some ideas.
Well, let's see. We have some people on. Let's see if they have any questions or thoughts, what you're hearing from colleagues or what you've experienced. Anything from our audience?
We've done too good a job.
That's always good.
So hypothetically, if when you signed your initial contract, it described malpractice in one fashion, and then the facility buys a different policy while you still work, which, you know, they didn't really explain how it was going to work until you go to leave.
Mm-hmm.
And then your broker says you don't need tail with the occurrence-based policy or the claims made. Do you take the broker at its word?
I'll start with Izzy, and then I'll give you the lawyer's answer, which will do nothing but confuse you.
Okay.
So what I would tell you is that likely as not, and when an employer changes from one policy to another, as long as they pick up the prior exposure, you're probably going to be fine with either company. Again, assuming that they've gone to a good carrier, or even if it's a self-insured trust, assuming that the language in the self-insured trust is adequate, then when they change the insurers that insure the self-insured trust, usually that shouldn't make a difference. But again, if you are worried about that, that is a question you can ask your HR person if you're in a hospital or in a large setting. And certainly you can ask your employer to put you in touch with the broker so you can ask those questions. But the real issue is if someone cancels a policy and doesn't buy prior acts coverage or doesn't purchase a tail. It's one of the things that we haven't touched on, but when you go from one claims made policy to another, you should almost always be able to purchase prior acts coverage over the previous years that you're with the other insurance company. That's a nose. And when you buy that, when that nose is built in there, you don't need a tail for the old carrier. You still need a tail if you cancel the new company. But that you can transition coverage from company to company as long as the new company continues to pick up the old exposure. That's called prior acts or nose coverage. And that works pretty well. But there are a few times when you can't get nose coverage. For example, if your claims experience makes it difficult and an insurance company says, I'll insure this midwife going forward, but I'm not picking up any of the prior acts, then you have to deal with tails at that point. But it all works very, very well as long as somebody keeps their eye on the ball.
So here's a question that has come around year after year after year with midwives who can't afford tail. How can I protect my assets if I choose to go bare?
And Joe, this one's yours.
Local counsel is important to involve. In many states, and you will find a very big difference geographically as you go across from the Northeast down to the South and out to the West, the Oregon Trail. Everybody that went bankrupt in the East wound up creating new cool bankruptcy rules as they went West. And that is basically the idea of how states moved. Each state is different. And so in many states, things like your home or your retirement accounts, those sorts of things are not actionable. You can't reach that money. So if somebody sues me and all I have in my wealth base is my home and my retirement account, I may be judgment proof. And you may be satisfied with that. You may, again, have to pay a lot of money to lawyers to prove your judgment proof, but you may be satisfied with that. In some states, you can attack some of those assets like your home. Before the bankruptcy reform, I live on a border state between Kansas and Missouri. And we have one really wealthy county in Kansas that has just super expensive estates that are on the Kansas side, specifically because people who lived on the Missouri side of Kansas City, Missouri, were facing litigation and simply moved all their wealth to Kansas, because at that point, under the bankruptcy statutes, they could shield their entire home. And so they would, if you want to have a $3 million house when you had a $2.5 million estate, you just move across, you move 16 feet and you were able to preserve your estate. So you have to look to your local law to understand how vulnerable you are. You also have to look to the probability of what your risk profile is. And that may be a complete assessment to how tumultuous the practice environment was. We've seen practices that have numerous lawsuits because there has been all kinds of turmoil in that practice. And we've seen other practices that maybe just the same amount of malpractice occurred, but it was loving and caring and people liked them. The single most common denominator about whether people will file a professional liability lawsuit has to do with the bedside care, has to do with how kind you are and how you care for people and how you respond to what they want to say and how you listen to them.
Hey, Joe, I need you to wrap that thought up, because we got a question that I thought so, but I wanted to transition. We have a question here, and this is somebody putting her kids to bed, so I'm not sure she can talk easily. Izzy, can you see that question in the chat board?
Do.
Okay, I'm going to let you field that one.
Okay, so generally speaking, the whole issue of collaborating physicians is a sore spot for midwives. Why should midwives be treated any differently than doctors are? And what makes doctors better than midwives? As a general rule, we don't really see a problem with a collaborating physician being a mile away. Frankly, I don't care if a collaborating physician's 100 miles away. We don't require collaborating physicians. That's the states do. Now, so some companies do. We don't. We believe that the midwives can make decisions by themselves. So the first part of the question about collaborating physicians, some insurance companies may, some insurance companies don't. Most insurance companies will go with state law. State law says you have to have a collaborating physician. They won't require it, but it won't matter because you can't open up an office without it. So that's one. As far as covering a facility and not covering the midwives, well, and Joe can address this better than I can, but I'll give it a stab. And that is, you can't sue a midwife. You can't sue a corporation for negligence, because not for professional negligence, because a corporation is not a professional. In order to sue the corporation for what's called vicarious liability for the acts of the professional, you have to sue the professional. Okay, and if you sue the professional and you sue the entity, the birth center or the facility, so now you have two pieces of the coverage. If all that's insured is the facility, some companies won't provide a defense for the midwife. Now, that's kind of crazy, you would say, because if you're not defending the midwife, how can you defend the corporation? But some companies say, I didn't collect a premium on it. I'm not providing a defense. That midwife is on their own. So as a practical matter, you can never rely on the fact that the facility is covered. You need to know that you're covered and the facility is covered. It's a good thing too, but that's their problem. You need to know that you're covered.
Yeah, your central problem is that if there isn't a settlement, and a large proportion of these cases settle. If there isn't a settlement and it goes to a jury verdict, that jury verdict is going to lay liability onto the care provider, and whatever share goes to the entity. The entity is liable because they're vicariously liable if you're an employee. And so that's going to be a transfer, but you're still liable. And so, if you dilute that logic in a settlement, you're going to get there in, whatever that insurance company that isn't going to pay for your defense, et cetera, is still going to wind up going, well, we'll still settle this case by X before it goes on. But if the case is disputed, even for irrational reasons, and I can tell you, as 20 years ago defending physicians and institutions, sometimes the most irrational reason was they didn't want a negative knock on their database report, and they didn't care. They thought that it wasn't their money. They didn't care how far they had to fight it. They just didn't want a negative word said about it on the database. And so they're willing to go down the line. So if you're dealing with that, you still are going to suffer a lot and have a lot of expenses and have judgments against you, which might put you into bankruptcy, which may be the only way to get out of it.
Thank you guys for answering that question. We have somebody just dropped in. I'm not sure if they messed up the time zones. That sometimes happens. We're about at the top of the hour to wrap up this discussion, but I wondered if the person who just came on, Aaron, if you had a particular question about the topic, or if anyone else has another question or parting comments from our two experts.
1.5.
Aaron, you're welcome to use the mic, or anyone else if you want to. You can wait just a second if you have a question.
So sorry, I think I messed up the time zone. Is this recorded?
Yes, it is.
Okay, great. Thank you so much.
Sure. Any questions from anyone, or Izzy? I'm going to turn to you as someone who many midwives reach out to. You want to talk to them about how they can reach you if they have questions or
Sure.
want to follow up?
I've been waiting all night for that question.
Yeah.
So we can be reached at, well, for me, it would be Izzy at CISinsurance.com. My phone number is 301-933-3373. Or you can just go to our website, which is CISinsurance.com, and that'll give you the links that you need to reach us. We don't charge for our time. We sell policies. If you have advice and you keep me on the phone for an hour, you'll get that hour free, even if you never buy a policy. So we very much enjoy working with our midwives and helping in any way we can.
Are there any states, Izzy, and I know one, so I'm asking this question, where you can't cover midwives?
So our program will not cover midwives in Kansas and Wyoming, and in New York and in New Mexico. Kansas, because of the way the laws are written, the same is about true of Wyoming. New York and New Mexico, because they're high claim state. Having said that, I can provide coverage outside of our program in all but Kansas and Wyoming. So we can cover New York and New Mexico. We just have to go to other carriers to get there. But midwives in every state should be able to find someone to cover them. And so if that comes up as an issue, I get a lot of calls from Kansas midwives. We used to be able to cover them, but unfortunately, Kansas makes that very difficult.
I was part of that difficulty, so I understand.
Part of the what?
Difficulty. I used to be one of the attorneys for the Healthcare Stabilization Fund.
Yep.
And it requires so many levels for insurance companies to come in that it's cost prohibitive for smaller books of business. It just isn't worth it. On the other side, just to defend Kansas and may rely on other similar states, there are only one or two that are like this, that have stabilization funds. In Kansas, if you participate in the stabilization fund for a period of time, then you have free tail.
It's 3
big-
years.
Yeah, that's the big golden apple. The state starts covering all your tail. All of you who have participated in this program and just come on, if you have questions and you may feel a little shy thinking, golly gee, I was just a little late and I really wanted to have this question answered, please ask it. We would love to do that. We're here to help you.
The other thing you can do in addition to reaching out to Izzy is you can reach out to us, Grow Midwives, on our website. There's a contact us form. We're glad to funnel questions through there as well. So I'm going to turn off the recording at least, and then we'll stay